All right, thank you, everyone, for being patient with us today. It's that time of the year, plus one. Madam Clerk, we go ahead and call the roll.
Representatives Bricken, Bulso, Capley, Eldridge, Gant, Garrett, Grills, Harris, Lambert,
Garrett.
Littleton, Parkinson, Powell, Russell, Stevens, Todd, Vice Chairman Jernigan, Chairman Farmer. Mr. Chairman, you have a quorum.
Thank you for that. Members, anybody have any recognitions or personal orders they'd like to take before we get started today? Going once, going twice. Okay. All right. We have a calendar. A couple housekeeping matters to take up first. Item 3, House Bill 2908 by Chairman Kumar. He's asked for that to be taken off notice. So without objection, off notice. And members and audience, item 7, House Bill 2689 by Chairman Doggett. He's asked for that to be taken off notice as well. Any objection? Seeing none. Off notice. And that brings us to our regular calendar for the day. That's item 1, House Bill 2647 by Chairman Reagan.
Good morning, committee. Hope you all are having a good day. I bring before you an amendment to House Bill 2647, drafting code 17253.
Members, any objection to adopting House Amendment 17253? Seeing none. I'm back on the bill as amended. You recognize.
Thank you, Mr. Chair. Members, as amended, this bill simply states that by July 1st of each year, the department, DCS, will publish on their website such agency's most recent annual inspection report completed by the department. And that is it in a nutshell. Ask for your support.
And thank you, sir. Members, I have Leader Lambert. You recognize.
Thank you, Mr. Chairman. And Chairman, I know we've talked about this previously. I have some serious concerns about, quite frankly, some of your Senate sponsors here and what could potentially happen with this bill later. I do think this is something that we could wait on. The report itself is something that I think that if we'll just ask for, they would generate. And so I would make a motion at this time for a summer study.
Thank you. Properly motion, properly second. Any objection? Seeing none. House Bill 2647 is sent to summer study.
Thank you, Mr. Chair and committee.
Thank you. That brings us to item 2, House Bill 2809 by Chairman Halsey. Sir, you've got a motion and a second. I'm looking at drafting House Amendment 14209. Would you like to move forward with that, sir?
Yes, sir. If the other amendment that makes the bills traveling with it.
I'm looking at one amendment that I have that we need to adopt it. Do you have multiple amendments or do you only have
No,
one?
the one that made the bill at the beginning, I don't know what the posture is. It's 008389.
Okay, members, we have House Amendment 14209 that we need to adopt. It makes the bill. You got a motion. Any objection to adopting that amendment, members? Seeing none. Now we're back on the bill. House Bill 2809 as amended. You're recognized.
Thank you, Mr. Chairman, and thank you for the time in the committee. This bill deals with LEOSA permitted officers who are retired. I don't know if you know what back President George Bush started the Law Enforcement Officer Safety Act and put it into law. And what it did was it allowed retired officers in good standing to be able to carry concealed in any state in the United States, irregardless of what local or state law said. And it was to put more boots on the ground and be used as crime increase. And what this bill does is, by the way, President Obama enhanced this LEOSA. What it does is most officers who've served 30 years and they retire in good standing, to get a LEOSA permit, you have to go to training every year. You have to qualify with your firearm every year. You have to submit your fingerprints every year. And then you can receive a LEOSA permit under this federal program. What this bill does is it says that a LEOSA permit holder in the state of Tennessee can carry concealed any place a uniformed officer can carry. Now, what's important about that is not just boots on the ground, but it also These guys, most all of them have 30 years experience. They didn't just go to a police academy at the beginning, but they went to 40 hours in service every year for 30 years. They qualified every year for 30 years. They've been through active shooter training for at least the last 20 or 25 since Columbine. They've had specialized education, specialized schools, and you've got all that experience laid out there. And this is a good avenue for those folks, and they want to be used in the community. They want to build relationships with school systems and be able to volunteer some time to go down and work with SRO, get to know the principals, get to know the students, get to know the teachers, and help supplement SRO programs. So that's the whole purpose of the bill, and that's what the bill does.
Thank you for that explanation. Members have any questions for Chairman Halsey? Vice Chair Jernigan, you're
Yeah.
recognized.
Chairman, are you trying to become an SRO? Is that?
No, but I was a Leosa holder until I started working part-time for Bluff City Police Department for the last 2 years.
Thank you, Chairman.
Very good. Representative Parkinson, you're recognized.
Thank you, Mr. Chair. And Chairman Halsey, I think this is a good bill, and thank you for the Obama nod. I appreciate it.
Yep.
Good job.
That was for you.
Very good. Members, anyone else? Anyone else on the bill? Any objection to sending House Bill 2009 as amended to calendar and rules? All those in favor say aye. Opposed, say no. Ayes have it. Bill moves on. Thank you.
Thank you, Committee and Chair.
We've already disposed of item 3. That brings us to item 4, House Bill 2372 by Chairman Terry. So you have a motion and a second there, and I'm looking at House Amendment 14730. Would you like to move forward with that?
Thank you. Actually, if I can say something, I'm going to end up taking this off notice.
Yes, sir.
And I do want to thank the chair and the committee. And following the passage of this bill through the subcommittee, the general sessions judges and the administrative office of the courts were able to resolve this issue without legislation. And so I appreciate everybody's help on this matter. And with that, I'd ask to take this bill off notice.
Good members,
This is 2372?
Any objection?
2372.
Very good. All right, off notice. All right, without objection, House Bill 2372 off notice. All right, brings us down to item 5, House Bill 2434. Got a motion and a second. I'm looking at two House amendments, Chairman Terry. The latest one is 17202.
Yeah, that is correct.
Okay, very good. Would you like to adopt that?
Yes, please.
Does it reroute the bill?
Yes.
Okay, members, you want to go ahead and put it on? Very good. Got a motion and a second. Any objection to adopting House Amendment 17202? Seeing none. Now we're back on the bill as amended, and I do have some folks that signed up to testify today, Chairman Terry, one way or another. But if you'd like to go ahead and we can talk about the bill now, you can explain it, and we can go out of session, however you want to.
Yeah, I can give you a brief description and we can go out of session and be fine. The issue at hand is that despite businesses having privacy protections in place, hackers and even foreign entities are wreaking havoc on businesses by maliciously gaining unauthorized access to protected information. In some instances, government is even requiring businesses to retain much of this information, like in healthcare. Yet government doesn't provide technological nor legal protections for businesses who are following these directions. This bill provides that a private entity is not liable in a class action lawsuit resulting from an event resulting in unauthorized access to or disruption or misuse of an information system or non-public information stored on an information system unless the event was caused by willful or wanton misconduct or gross negligence on the part of the private entity. The individuals will still be able to sue individually for negligence, for willful, wanton misconduct, or gross negligence in civil court. This bill just states that the burden of proof is raised on a class action lawsuit. And so I'll be happy to go out of session and we can talk about it later.
Very good. Members, any objection to going out of session? All right, seeing none. If we could, I have Mrs. Sarah Carey, are you here? Ma'am, if you just come on up and have a seat there, just be sure your microphone's on. You push a button there, little speaking face, and make sure your red light's on. If you'd introduce yourself, you got 3 minutes, and then an unlimited time for questions. Try it one more time.
How's that?
That's that.
All right. Thank you, Chairman Farmer. I appreciate the opportunity to speak on this. This is a well-intentioned bill as it is written. The problem with it is it doesn't help address the situation advanced by the gentleman who put it up. The problem is it will result in more lawsuits, not less, by prohibiting class actions to be brought. It also, because class actions are intended to bring a host of cases in one lawsuit, resulting in fewer costs, fewer litigation costs for the defendant, for the plaintiffs that have been wronged. So as a base matter, the bill does not purport to help in the manner that it is put forth as advancing. The second part is it's too broad. It protects all people, all companies, including foreign actors, including TikTok, including Google, from the negligent maintenance of our data that leads to data breaches that occur. And so that's the opposite of what is needed in Tennessee. Instead, we need more protection for Tennesseans for data breaches, not less, which is unfortunately what this bill does. Thank you.
And thank you so much. Members, any questions for our speaker? Thank you. And next on the list, I have Mr. P, Joey P. So if you just come on up and same protocol there, just have a seat. Be sure your microphone's on. There'll be a red light indicating that. Introduce yourself, who you're with, and you'll have 3 minutes for your comments, and then unlimited time for questions if members choose to ask those. Thank you.
Okay. Good morning. My name is Joey P. I'm a resident of Rutherford County and actually one of the constituents of Representative Terry's 48th District. I'm also the CEO of Murfreesboro Medical Clinic. In April of last year, it became evident that we were undergoing a cyber attack by what came to be known as Bean Lane, which are an internationally known group of cyber terrorists, state-sponsored according to the federal law enforcement that assisted us in this matter. We fought them for a week. Everything was quiet. And then Thursday, Friday, the federal law enforcement says we see no more chatter about Murfreesboro Medical Clinic on the dark web, but we just see Joey P. and his wife's personal information for sale. That's a very disconcerting feeling. Then on Sunday morning, April 30th, we started getting ransom notes from hacked email accounts out of Canada saying that we have your data and you have so many days to engage with us and pay us these monies. And we shut down for 4 days. We're the largest provider of ambulatory medical care in Rutherford County. We were shut down for 4 days, disadvantaging probably 2,200 patients a day over those 4 days. Even when we opened back up on Friday, May 5th, our ability to see and treat patients then and for the next probably 3 weeks was greatly limited because of the damage done by this cyber attack and our attempts to get things restored so that we could again see patients. When the young lady spoke a moment ago about negligence and things, we don't believe we were negligent. We've got to be perfect every time. These cyber criminals, and these, according to federal law enforcement, are not a bunch of kids sitting in their grandmother's basement. These are state-sponsored cyber terrorists. The group that did ours was well known to the federal law enforcement agencies that, again, were assisting us. This bill does nothing to help me or my organization. What's done is done. But another organization could be spared from bankruptcy. Fortunately, we're not there. We're close. If the settlements for this lawsuits that we were hit with had gone a different way, we very easily could have been speaking to you from bankruptcy as well. 9 days after our hack, we got the first class action lawsuit. 9 days. During that time, they're claiming all this damage. We're still getting interaction from the bad actors saying, if you don't give us this money, we're going to release your data. Nothing had been released yet, and we already got the first lawsuit claiming damages. About a month ago, I spent all day in a room mediating these suits to reach a settlement. We spent all day in the room reaching a settlement and did not spend 1 minute talking about the merits of the cases. It was all about the money. In these settlements, the 8 named plaintiffs in the 6 cases filed against us as class action will get a couple $1,000s. The attorneys are splitting several $100,000. The other, if you've been involved in any of these other class action settlements and things you may get from AT&T or anybody else, you get a $10 gift card or something like that. It is getting to the point of ridiculousness. Just this morning, I got noticed.
Now you went over your 3 minutes a little bit. I was trying to find a good spot for you to stop, but I didn't feel like you were going to stop there. So we have
I'm on a roll.
questions from the committee.
Passionate about this. Yes, sir.
You are, sir. I have Chairman Todd, you're first on the list, and I'll come to you, Representative Parkinson.
Thank you. The first question I have is, and I want you to finish whatever you had to say, but in that, I'd like for you to answer, do you feel like there are groups or firms that are literally looking for these opportunities in order to file a lawsuit, even when there's been no potential damage, as you said, 9 days and no data had been released? Do you think there are predatory folks out there looking for this opportunity?
Mr. P, you recognize.
Absolutely. The lead counsel on our particular group of class action suits had a backlog of over 400 cases just like this, to the point where he was trying to hire additional help from the firm representing us. So absolutely. At the time that our hack occurred, there was also NextGen Healthcare, Blue Cross Blue Shield of Tennessee, HCA, TriStar Health, something called the Tennessee Teachers Retirement Plan, something like that. As I was just saying, Change Healthcare is the largest intermediary of healthcare claims in the country and probably in the world. About a month ago, they were hit with a ransomware attack that basically shut down a lot of physicians and medical practices' ability to bill and receive payments. Fortunately, our group worked through with our practice management system to find additional avenues. I got notice this morning that Change Healthcare just got hit again with another cyber attack. As healthcare entities, we are held to a little bit of higher standard with the Health Insurance Portability and Accountability Act, or HIPAA standards, but also the state privacy standards, to where we're subject to penalties and oversight by the Office of Civil Rights at the federal level, and then also at the state level for protecting our data. We take that seriously, but there are firms that this is what they do. They were putting ads on Facebook, on Instagram, on TikTok. Are you a patient of Murfreesboro Medical Clinic and harmed by the cyber attack? Call us now.
Chairman Todd, any follow-up? Members, anyone else for our guest speaker? All right. Thank you, sir. Appreciate
Thank
you
you,
being
Mr.
here.
Chairman.
That's all I have on the list. Members, any objection going back into session? All right, we're back on the bill as amended. House Bill 2434. Chairman Terry, you recognized.
Thank you. And as you heard from the witness, and obviously the passion and what's gone on, this is a serious problem that we are dealing with in the state and across this country. And even when you put in what you believe are reasonable measures, you can still get hacked, and you can still end up getting threatened for lawsuits. And so to me, that's kind of like, you could have a home security system and have a dog and have self-defense protection at your home, and it doesn't mean that you're still not going to get broken into. And then now you have insult to injury in that you can get sued for that. So I'm happy to answer any questions.
And thank you for that. I have Representative Capley, your first on the list. We'd have a couple other members on there. May I move you down a couple spots? Appreciate that. Representative Garrett, you're recognized.
Thank you, Mr. Chairman, and thank you, Representative Capley, for letting me voice a couple of concerns that I have for the piece of legislation that I believe I've talked with the sponsor with. I've got two kind of major issues with this piece of legislation. The first one is the burden, right? You're making it a burden where simple negligence to gross negligence is now the standard in a class action, right? Simple negligence is where, and I have sympathy for those that testify that are in a healthcare world, that the burden should be higher when you have folks' healthcare information, not just their social security number, their address, et cetera, which is what maybe Equifax or someone like that might have. But it's incumbent upon those companies to make sure that they have the proper processes in place to protect those folks' data. You mentioned that the government doesn't provide resources or guidelines, and in my opinion, they shouldn't. Because the industries that are involved in this must adapt. If we have a statute that says everything you're supposed to do, well, guess what the hacker is going to do? Go straight to that statute and say, well, they're doing X, Y, and Z. We easily can manipulate that firewall, et cetera. If we, the government, give them a blueprint on how to protect their data, that's up to the industry to figure out. because we need to provide to protect Tennesseans that this is a crime if this happens. They've got to figure out the industry should adapt to protect people's data. So my two things with that is that if you're going to increase the standard to gross negligence, that's a higher bar of the activity that was conducted, saying that it is not only just, oops, we did this and we should have protected it. Now you're raising the bar for a plaintiff in a class action to say that it was so grossly negligent that it goes against so much the standards in the community that it was almost deliberate, that it was almost intentional for this particular company or whatnot to provide access to their data for the hacker. And no company wants to do that. No company intends to hold this sensitive information for Tennessee consumers that they intentionally or maliciously or so recklessly left their data processes so vulnerable to hackers that they were grossly negligent. That's the standard now that this piece of legislation provides, that they almost had to intentionally provide this information before there's an action to recover. So that's a major problem I have with this for people to recover. The second problem deals with eliminating the class action. I'm no fan of class actions. I practice law. I've never been involved in a lawsuit that included a class action. But here's where I have some heartburn to eliminate that. And I'm not trying to pick on any particular industry, but if you have an Equifax situation where they have millions and millions of Americans and people across the world, their information, and there is a breach of that data, the same breach, you have the same damages to the same amount of people. Their remedy in that situation is a difficult one to value, right? It's difficult to say, well, what can Equifax, if they were simply negligent, and this, in my example, which in my opinion shouldn't be the case with the sensitive information that they have for everyone that deals with a credit score. In this instance, you're going to make it where there's no remedy. Instead of one of the witnesses testifying, instead of being really one lawsuit with knowing what the damages are, knowing what happened, there is a remedy that sometimes they provide, and sometimes they provide credit protection for the next 5 years. We'll clean up your credit, et cetera. If someone hacked you, copied your identity, and ran down your credit score, so to speak. Now with this, you're going to have thousands of different lawsuits across the country in different courts, different remedies, different plaintiffs, and it's going to make it impossible for them to get relief to negotiate with an Equifax or et cetera, similar company, to figure out what the remedy would be. When these plaintiffs, as individuals, their damages don't amount to a lot, right, on an individual basis. But when you have millions and millions and millions of people that have been hacked and their identity has been stolen, accumulatively, those damages are great. And that's a bargaining chip to make sure companies like Equifax, it's also a deterrence that they must provide systems to protect people's data. If we lose those two things, you are making it easier for these companies to subvert their duties and responsibilities to make sure people's data is protected when they don't have accountability. So those two things, I'm very concerned about this piece of legislation, because this is a unique area for people's sensitive information. It's not a simple remedy for one person. Cumulatively, the effect of that is the leverage that people have to make sure this doesn't happen again. So with all those reasons in its current form, I just cannot support the legislation the way that it is, because I'm worried about how this is going to affect the Tennessee consumer if they're ever subjected to a hack. And now the bar has to be that it was an intentional conduct for them to pull together in a class action and seek relief. So I've got some real concerns, but thank you for bringing the piece of legislation.
Chairman Terry, any follow-up there?
Yeah, thank you. And I appreciate the comments. And I agree with you. As I've looked through this issue and studied it and tried to find us the right language, the right solution, it's not simple. To that point, I looked at, is there a way that we could put in there what those standards may be? If you do X, Y, or Z, are you maybe a safe harbor, or you have a rebuttable presumption that if you've done this, hit that reasonable care, and that's just something that's very difficult for me to be able to, that I've not been able to find. As far as, the burden of proof, you are, to that point, you mentioned about you have to adapt, and as things change, you do have to adapt. And that's why it's been difficult to find where if you there's, on your computer, if you have some antivirus software and then some hacker finds a way into that, then you have to adapt and you have to. So if you put something in law, I do think that's we have to be fluid in that manner. So I don't disagree with you on that. I do want to say though, when you talk about burden of proof, this piece of legislation isn't necessarily groundbreaking in that. A few years ago, we passed the Tennessee COVID-19 Recovery Act and put in similar measures in that, but it was for all suits, not just for class action lawsuits. And it said, notwithstanding any law to the contrary, there is no claim against any person for loss, damage, injury, or death arising from COVID-19 unless the claimant proves by clear and convincing evidence that the person proximately caused the loss, damage, injury, or death, or by an act or omission constituting gross negligence or willful misconduct. So we've done something similar to this before. So anyway, hope that answers your questions. It is a difficult situation, and I'm trying to find the right way to go forward.
Thank you. Representative Garrett, do you have any follow-up, sir? Go ahead. You're recognized.
Thank you, Mr. Chairman. Thank you, Chairman Terry, for that. But my concerns are still there in a sense of COVID-19, where there was a lot of controversy around there. That's a completely different situation than what we have here. But my final comment is I spent quite a bit of time on the data privacy bill that had several ways to cure a defect if a company violated our own personal information. Now, granted, Equifax, the examples that we've been talking about here are exempted out of that piece of legislation, but there are ways that you can have an ability to cure. The NIST guidelines under that data privacy bill, I would encourage you to take a look at that. If there's a company that follows that protocol, which is guidelines of how you protect your data, if you did all of those things, if you met criteria under the NIST, then you would have a defense. You would have an affirmative defense that you did not breach the data, so to speak, if you were hacked under those circumstances, if you follow those guidelines. If something like that was potentially in your bill, I could see where I could get comfortable where there could be some sort of affirmative defense. But to eliminate someone's right to pull together when Equifax, and again, I'm not saying Equifax is doing this. That's the one I think we can all relate to as to what data they harbor. And if there's a breach, then you're just cutting off the ability for people to pull together to maximize the benefit of that relief for the damages for someone stealing their identity. And I think the NIST regulations would provide a framework for a good affirmative defense, and I would encourage this legislation to conclude that. And I know what stage we're in, but again, without that, I just can't support the piece of legislation. But thank you very much for letting me make my comments, Mr. Chairman, and to the sponsor.
You're welcome. Chairman Terry, any follow-up to that?
Good. Thanks.
Okay. All right. Next, I have Leader Lamberth, sir, has stepped out for a moment, and that does conclude the list there with that. All right. Anything you'd like to follow up with, Chairman Terry?
No.
I do have Leader Lamberth there. Sir, you were on the list to speak. You're good? Okay. Very good. Any closing remarks, sir?
I just appreciate your support. We have these businesses that are in difficult situations, and appreciate your support.
All right. Anyone else any comments or questions? Seeing none, are we prepared to vote? Any objection to voting on House Bill 2434 as amended to go to calendar and rules? All right. Seeing none, all in favor say aye. Aye. Opposed say no. Ayes have it. Bill moves on.
Thank you, Chairman.
Thank you. Brings to item 6, Representative Chisholm, House Bill 2046. You got a motion and a second, sir. I'm also looking at House Amendment 3513.
That's correct.
Is that something you'd like to move forward with?
Yes.
Very good. You've got a motion. You have a second? Okay. You got a second. Does it rewrite the bill?
Yes.
Okay, very good. Members, we'll go ahead and put that on. Any objection to it? All right. All those in favor of adopting House Amendment 3513, say aye. Aye. Opposed? Ayes have it. Now we're back on the bills amended, and you're recognized.
All right. Thank you, Mr. Chairman and committee. Currently, when the Department of Children's Services make a new rule or a new policy, they send a report to the Judiciary Committee of the Senate, and the Civil Justice Committee of the House. So what this bill would do is, all it would do was add government operations of the Senate and the House to that list. And with that, I stand by for questions.
Very good. Members, any questions for Representative Chisholm? I don't see any questions. I've heard the question been called, the objection. Seeing none, looks like we're ready to vote. Send House Bill 2046 as amended to calendar and rules. All those in favor say aye. Aye. Opposed, say no. Ayes have it. Thank you.
Thank you, Chair and Committee.
Brings us to item 7, which has already been taken care of there. It's been taken off notice. That was 2689 by Representative Doggett. Item 8, 2644 by Representative Leatherwood. So you've got a motion and a second. And I'm looking at 2 House amendments, 15480 and 18139.
That is correct, Mr. Chairman.
Very good. Members, do I have a motion and a second? Very good. You got a motion and a second on both of those amendments. Does either one, would you go ahead and just tell us what both do, and then we'll go from there?
Okay. What this bill does, as amended, it eliminates some of the open-ended timeframes with the process of adoption. And this bill was brought to me by the Tennessee Bar Association, the adoption section. And its purpose is to try and speed up the process, so it eliminates some of the open-ended timeframes by adding some timelines to the adoption process.
Very good. Thank you for that explanation. Members, any objection to adopting House Amendment 15480? Seeing none. And then also, members, I have House Amendment 18139, which he also explained. Did you explain that one as well, sir?
All that one does, the First Amendment created
members.
Subsection M in there. And again, just trying to be more concise and clear, it, instead of adding a subsection M, it puts that information into the existing subdivision L.
And thank you for that explanation. Remember, any objection in adopting House Amendment 18139? All right, seeing none, it's adopted. And members, without objection, we're going to roll both of those House amendments into one. And sir, you're probably recognized on the bill as amended.
Okay, and the description I gave before was of the bill with both of these amendments on there. So with that, I'm ready to answer any questions.
All right, very good. Members, any questions for Representative Leatherwood? All right, got the question on the bill. Don't see any objection. Looks like we're ready to vote to send House Bill 2644 as amended to calendar and rules. All those in favor say aye. Aye. Opposed, say no. Ayes have it. If you want to be recorded as no, see the clerk. Brings us to item 9, House Bill 2032 by Representative Barrett. So you got a motion and a second. You're properly recognized.
Thank you, Mr. Chairman. And as we've discussed previously, we're in the season where the Senate is sending our bills off to pasture for the rest of the summer. So I will be pulling this off a notice, but with your permission and discretion, I'd just like to have a few minutes to talk about the bill. Look, House Bill 2032 is a issue that I've been working on ever since I came into this body. And as it relates to our exercise of our Second Amendment rights, particularly for individual Tennesseans who have enhanced carry permits. Throughout this country, we have protections through the First Amendment and Second Amendment under the Constitution, and individuals are allowed to go onto private property, exercise their First Amendment right without fear of being arrested and prosecuted criminally. And this bill simply seeks to exercise that same protection for the exercise of the Second Amendment right, particularly those who have a permit to carry onto private property. So as we continue to work on this, I will bring this bill back and we'll continue to hopefully build consensus across the aisle. And with that, Mr. Chairman, I will pull House Bill 2032 off notice.
Appreciate that. And thank you for that explanation. Members, without objection, House Bill 2032 will be taken off notice. Thank you. And that brings us to House Bill, item 10, House Bill 2035, Representative Barrett. You got a motion and a second. I'm looking at House Amendment 17797, sir. And you
That
got
is
a motion
correct.
and a second. Does that amendment make the bill?
It does.
All right, members, we want to go ahead and adopt that. Any objections to adopting House Amendment 17797 to House Bill 2035? All right, seeing none. Now we're back on the bill as amended. You're recognized.
Thank you, members. This bill seeks to maintain clarity across the state of Tennessee as it relates to extreme risk protection orders and red flag laws. As we've seen with the current White House administration creating the Extreme Risk Protection Order Resource Center, the intent is to subvert the will of the legislatures of this country to try to go into counties and municipalities to create confusion and have different ordinances across these jurisdictions. So this bill would simply preempt that field of law at the state level so that all extreme risk protection orders or red flag laws would have to originate in the state legislature here in Tennessee. This bill or this law has already been in place since 2020 in Oklahoma. It's been adopted in Wyoming, and I hope that Tennessee will do the same.
Very good. Thank you for that explanation. Members, any questions? I see Representative Powell. Your hand was up first. Are you recognized?
So we continue to see inaction in our state by the legislature in dealing with serious gun control measures. And so you're telling me if a city wants to take action and create some sort of law around ERPO and protections that you're basically removing the ability for cities to do that. Is that correct?
Representative Barrett.
Yeah, Representative, in order to make sure that gun owners in Tennessee have clarity across the state from Memphis to Mountain City as to what their rights are under the Second Amendment in this state, yes, this law would prohibit having multiple different ordinances across the state.
Representative Powell, any follow-up?
I just think that's contradictory to, trying to have government, local control knows best. And, we are seeing action in some of our cities and different efforts that are being taken to address the issue of gun violence in our state. And, my concern here is I think these red flag laws are a wonderful option. I've seen multiple Tennesseans agree with this. I think overwhelmingly red flag laws are supported. However, we're here making sure that we're preventing some cities and communities who want to take bold action to address gun violence, not being able to do that. And so while I understand we want to have uniformity of the law, I also want to have safe communities. And I think that saving safe communities and saving lives is more important than having uniformity of the law, because I don't agree with some of the laws that are being taken. And, these are very helpful laws and actions that can happen, that can be put in place to deter gun violence. So I'm opposed to your bill. I'll be voting no, and I hope my colleagues will join me as well. Thank you.
Representative Barry, any follow-up, sir?
Thank you for your comments, sir.
Thank you. Members, anyone else? All right, seeing none, we ready to vote? Looks like we are. All those in favor of sending House Bill 2035 to the Criminal Justice Full Committee, say aye.
Aye.
Opposed, say no. Ayes have it. If you want to be recorded as no, see the clerk.
Thank you, Chairman and Committee.
That brings to item 11. Representative Fritz, House Bill 2082. You've got a motion and a second on the bill, sir. And I'm looking at two amendments here. I have 14746 and 17852. We can take those up one at a time. So 14746, you've got a motion and a second on that one. So if you go ahead and just let us know what that does.
Thank you, Mr. Chairman and committee. Good morning. I appreciate your time on this. I'll speak to both amendments briefly, if you don't mind us, Mr. Chairman. The amendment that makes the bill on 14746, there has been what I consider a friendly amendment offered in 17852.
Okay.
That makes some clarifications to the bill.
Members, I have a motion and a second on 17852 as well. Okay, very good. Go ahead, Representative Fritz.
Thank you again, Mr. Chairman and committee. This legislation makes a change to Title 39, 17, 1307.
Hey, Representative Fritz, let me ask you a quick question.
Yes.
So we're on the amendments. So do these amendments make the bill? Okay.
The first one does.
Okay, very
Mr.
good.
Chairman,
Members,
And the second
do
one,
we want to go ahead and put the amendment, the first amendment, House Amendment 14746 on the bill since it does make the bill. Any objection to that? All right, seeing that, all those in favor of House Amendment 14746, say aye. Aye. Opposed, say no. All right, now that one's adopted. And let's move down to 17852. What does it do? You've got a motion and a second on already. So does it make the bill as well, or?
Mr. Chairman, 17852 simply adds a sentence to the end of my First Amendment of
Okay.
what is now the bill.
Okay, very good. So it's not a substantive change?
No.
Okay, members, are we ready? We want to go ahead and adopt that House Amendment. All right, all those in favor of House Amendment 17852, say aye. Aye. Opposed, say no. Ayes have it. And without objection, we'll roll those amendments into one. And now we're back on the bill as amended, and you're recognized, sir.
Thank you, Mr. Chairman. Thank you for your patience with me. This bill, as amended, simply deletes the phrase lawfully carries a handgun pursuant to 171307 and replaces it with is not prohibited from possessing a firearm. The other changes made are cleanups, if you will, and result in the change of the bill. Why is this legislation needed? Currently, our law states that someone who carries with the intent to go armed, a firearm or a club commits an offense. This is in direct opposition to our Second Amendment and to the U.S. Constitution, which states the right of the people to keep and bear arms shall not be infringed. Over the years, we've added exceptions to the code in subsections E and G. However, we're infringing upon the rights of citizens to bear arms because the citizens must still appear in court and prove that they meet these exceptions. Recent rulings by the Supreme Court have also affirmed this right to bear arms. By continuing to make carrying a firearm an offense, we're allowing the narrative of guns are evil to overshadow the protected constitutional rights. Although it has become trivialized, the statement that guns do not kill people, people kill people is true. It is impossible to legislate what is in the heart of an evil person. Someone who has hatred and violence in their heart is not going to be concerned about whether they are committing an offense by carrying a firearm. What our current statutes do then is hold criminally accountable the law-abiding citizen. Beginning with the Declaration of Independence, our founders enumerated what they believed to be creator-endowed rights. In the Declaration, they described life, liberty, and the pursuit of happiness, and they went on to say in that declaration that the role of government was to secure these rights. What I offer you today is intended to do that. Our U.S. and Tennessee constitutions provide more detail on exactly what those rights are and what constitutes liberty. The right to keep and bear arms is closely tied to the idea of self-preservation, the first law of nature. And I would submit to you that government does not have the authority to dictate by what means someone can protect themselves. I'll ask you briefly, if you would, Chairman and Committee, to go with me on just a little bit of a journey that I've been on in life. I would ask you to go with me to the Texas border of last summer. I would ask you to hear the words of those elected officials in McAllen, Texas, who said to many of us that there was a lawless state at the border, who said to many of us that those cartels that we have allowed to come into this nation were knocking on the doors of Texans' homes and demanding that they leave. These are armed units of foreign adversaries. I would ask you to consider that we just heard this week from one of our congressmen that between 20 and 25,000 aged 25 to 35 military-aged Chinese nationals have entered the United States. I too think that's a sad thing. And I think that to infringe or restrict the rights and criminalize the rights of the law-abiding Tennessean to defend themselves at this point in time or any other point in time is the wrong thing for us to do, and we do not have the authority to do so. I would offer to you that the recent report of a knock on the door at a home in Texas where the criminal cartel instructed the homeowner that they must get rid of their dog. The dog was disrupting their trafficking activities. The owner of the home refused to do that and soon found that their dog had been killed. What I offer to you, these graphic examples, my friends, my colleagues, my fellow citizens, is that we have in this nation and by our founders and our Constitution, the right to self-preservation. And that is closely tied with our Second Amendment right. I would offer that it
Representative
is
Prince, we have-
improper for us.
It's been 5 minutes, so if you can go ahead and
I'll
just
close
wrap it up.
one
Thank you.
sentence. Thank you.
Thank you.
I would offer that it's important for us to defend the rights of our Tennesseans. We are each oath bound to do so. And I would ask for your support and answer any of your questions. Thank
Very
you,
good.
Mr.
And that was right
Chairman.
on 5 minutes. I gave about a 20-second heads up there, so well, per our rules there. Members, do we have any questions for, excuse me, folks, if we're trying to conduct business here, and I'm about to call on some folks that's probably going to agree with some of you. So Representative Powell, you're recognized.
I guess I'm at a loss for words. You know what? I'm going to pass because I don't think it would be helpful to words that come out of my mouth to feel how I truly feel about what this bill would do and the way it would harm our Tennesseans and our families and our children. If you can come back to me, Mr. Chairman.
Thank you. Thank you, Representative Powell. Sure will. Representative Todd, you recognize, sir.
Thank you, Mr. Chairman. And I'm not at a loss for words when it comes to this topic. This is a very serious matter that needs to be corrected. We've had on our books for too many years now restrictions on a basic civil right that Tennesseans have under the U.S. Constitution. And our own Constitution has a violation in that puts the ability of lawmakers to restrict that civil right, and it needs to be removed. And there's an effort to do that right now. And I'm glad to get behind that effort as well as this one. This is a very important bill. As many of you know, I and Chairman Grills on this committee and others have carried similar legislation in the past. And if this doesn't get across the finish line, we will continue to do so because the basic civil rights that the sponsor mentioned just in his opening remarks is undeniable. These rights are unalienable. You can't even give them away. That's been shown in court case after court case, that these basic rights are endowed by our Creator. They are provided by our Creator. Y'all are free to leave. We're trying to conduct business.
Chairman
Thank you,
Todd,
Mr.
Chairman
Chairman.
Todd, I'm going to ask you all just please be respectful. We're being very respectful to you all. Please show that as well. I appreciate that. Thank you. All right, Chairman Todd, you recognize. Go ahead.
Thank you, Mr. Chairman. These restrictions on these civil rights have been shown at our highest level of jurisprudence in this country. The Supreme Court has ruled that these restrictions are unconstitutional. And so I applaud the sponsor for trying to get this done, to try to get at least this set of restrictions corrected in our code. 3917, 1307A1 is definitely a violation of the U.S. Constitution and needs to be corrected. So I appreciate you doing this. And Mr. Chairman, at this time, I also request a roll call vote on this bill.
Noted. Thank you. Have Vice Chair Jernigan. I did. Yeah, Vice Chair, you're recognized, sir.
So I want to say a few words. I guess I'll start historically. When you talk about the right to bear arms, I do. Just gonna lean forward into this.
There you go.
Okay. I think I'll start historically when the right to bear arms, it was to bear arms at that time meant military service. And that's why it says right to bear arms and there and to be well regulated. And I'm not going to go, I've been through the history of this in this committee a lot, but I'm just going to fast forward to Heller, right? The Supreme Court case in which Scalia made a departure from a traditional of what bear arms meant, and that's fine. He said that you can keep a firearm, a handgun, and a long gun in your home, but after that, it would be up to the states to decide. Now, I think a constitutional right and what's constitutional are separate. And for instance, it's constitutional for the state of Tennessee to deregulate, and that's what's happening here. It's also constitutional, for instance, the state of Illinois, who banned semi-automatic firearms, and the U.S. Supreme Court refused to take it up. So it's constitutional. It's constitutional on both fronts. It's not a constitutional right. It's up to the state to decide what's constitutional and what's not for the member. I've heard you say that in your statement that guns don't kill people, but people kill people. That this is true, and unfortunately, we let anybody, all the people, to have access to it. I've heard Representative Warner say that you could put a table out there and put a gun on it, and that gun's not going to kill anyone. However, we'll let anybody in the room go over there and get the gun without a background check, without any kind of mental stability, any kind of training, any kind of firing of the weapon. And now we're going to lower it down to 18 for, and this is where I get concerned with the bill as well. I've had 4 18-year-olds and they can't clean their room, much less I worry that one turns 18 in November and they're still in high school, and now they're allowed to carry, and that's fine. And it's their right. You said it's their lawful right for abiding citizens to carry the weapon, and it's lawful until the day that it's not, and someone cuts them off in traffic or someone pops off in school. And just as my chief did in this police, the chief of police in Nashville told me, he says, we are resolving now everyday conflicts with guns. It used to be a fist fight, and now they're pulling out weapons to decide the fate of folks. And it worries me that to a scenario to where you turn 18, I go to Craigslist, I meet someone in a Walmart parking lot, I buy the weapon, I put it on my shoulder, and now I can go walk down the street with it, and never been trained, never fired it. And I get that when you turn 18, you're eligible for the military service, but at least there you're trained on how to use a weapon. And some 18-year-olds don't qualify for the military. And so it's very broad. It bothers me, and I just wanted, and I'm sorry, your office is across the hall from mine, and I should have went over and, because usually you're very courteous of telling me that you're no on my bills. I should do the same for you, and but thank you for listening to my comments. I really don't have a question for you, but I in the present form, I can't support the bill, but thank you, sir.
Any follow-up, Representative Fritz?
Thank you, Mr. Chairman, and thank you, Representative, for your comments. I do treasure and appreciate your friendship, and I'm glad that we are officed across from one another. I would touch on a couple of things since you mentioned rulings of the Supreme Court. I would first offer that we do not prosecute crime in advance of its commission in the United States. There has to be a crime before we prosecute against it. To get to the point where that we would restrict because something might be problematic is not an American thing to do. And I would read from New York State Rifle and Pistol Association versus Bruin. And it says, I'm just going to read a couple sentences, Mr. Chairman. In keeping with Heller, we hold that the Second Amendment's plain text covers an individual's conduct. The Constitution presumptively protects that conduct. To justify its regulation, the government may not simply posit that the regulation promotes an important interest. And I think oftentimes that's what we do to justify the restriction of our fellow citizens' liberty, is we posit that it serves an important interest. And we have the court here saying that that is not permissive. I would offer just one other quick comment, and I'll read this. This is from Andrews v. State. The Tennessee Supreme Court likewise held that a statute that forbade openly carrying a pistol, publicly or privately, without regard to time or place or circumstances, and that was in 1871, violated the state constitutional provision which the court equated with the Second Amendment. And that was done so even though the statute did not restrict the carrying of handguns. And so I understand, because we made this change in 1989, up to 1989, this was not an issue in the state of Tennessee. And we made that change. And so it does leave some discomfort, some miscomfort with a change back to what is constitutional. But I would offer to my colleagues and ask for your support, this is the right thing to do.
Okay.
And Vice Chair Jernigan, any follow up to that?
I'll just follow up real quick.
Go ahead. Take time.
Two things. You cited Bruin.
Yep.
And that's fine. What Bruin was they went in with with handgun permits. And the problem within New York is that they said that you may have a permit or not. It was an arbitrary decision whether they wanted to do it or not. In Tennessee, it's a shall state. So that they were just saying that the permit process was unconstitutional. Doesn't mean that you can't do permits. Or that was really, really narrow. Second, and I'm glad you cited that case. I'll tell you a case, Armette versus Tennessee, 1840, the Supreme Court here in Tennessee, the Tennessee Supreme Court justice said, because I mentioned before about bearing arms in military service, is that you could hunt elk, buffalo, deer for 40 years and never bear arms. That's what he said, not me, because it was a military service. And so I tried to not go through the history of it, because it doesn't really matter what the history says after Heller, because Heller changed it all and we have to abide by what Heller says. Bruin just backed up Heller in a very narrow way as far as the state making the decision, but the state of New York made it, they just had a bad policy. They got cleaned up through Bruin. So I would just, I don't want to have a running debate, but Chairman, thank you so much. And I'm done. Thank you.
No, I appreciate that. Representative Fritz, good. Okay, good deal. Representative Powell, sir, I'm going to circle back to you.
Thank you, Chairman. You know, I feel like we are putting the worship of the gun ahead of the love of people and lives. What we have lost is, in the Constitution, all the talk about the Second Amendment, is the ability to have the pursuit of life, liberty, and happiness. And when our communities are overrun with guns, and we continue in this body to pass legislation to increase the proliferation of guns in our society and our state, we are making Tennesseans much less safe, much less secure. And when you are passing a bill that essentially, even if someone you know is a risk, is a danger, has an ability to do harm, but you're allowing that person to go armed in a very offensive way, in a very scary way. And the way this expands the number of guns from not just handguns, but to long guns and other weapons is ludicrous. And to allow this to even have, for younger people, as my colleague from Davidson County said, who, we know the brain is not fully developed until it's 25, but to have and carry these weapons is extremely offensive to me. When I have forced myself to look at some of these crime scenes following mass shootings, and you think about those little bodies who had no chance against these weapons of war, who were ripped apart by these dangerous weapons of war. Yet, we're here trying to make sure that more of those are in the hands of Tennesseans, not less. Law enforcement, the types of weapons that we're talking about, they don't even have that much firepower. That's what scares me, is that we can be overrun with lawlessness for people that have so many guns. And we've seen this. We saw it at the United States Capitol. We've got rules here where people can't bring guns in. We've tried to ban signs, but we're not banning guns. We're increasing the ability to have guns. I wonder how comfortable anyone on this committee would feel if everyone in the audience in front of us didn't have a sign, but they had a gun. I know I'd be terrified. I wouldn't be sitting here. But that's what you want to have in our society. I'm going to put aside some of the comments you made that I totally disagree with in your remarks. I find to be untrue and offensive. And just say that I hope and pray that we will come to our senses and do everything we can to stop gun violence and mass shootings in our country. The one common denominator with every mass shooting, there's one. It's been blamed on multiple things, but the one commonality is guns. Thank you, Mr. Chairman.
Representative Fritz, any follow-up, sir?
Thank you, Mr. Chairman. Just briefly, thank you, Representative, for your comments. I would offer just a couple quick things. There's nothing you'll find in this legislation that proliferates firearms. It does proliferate liberty, and that is our responsibility to do that as elected officials. The comment about being overrun with lawlessness, those are some of the cases I have made for what I have seen with my eyes, Representative, at the Texas border, what I've heard from other Americans say. And they have offered very assertively these words: it's coming your way. I hope I'm wrong about that. I hope they're wrong about that.
Please refrain from speaking while someone else is speaking. Please. Representative Fritz, you recognize.
I'll close quickly. Thank you, Mr. Chairman.
Thank you.
I hope I'm wrong about that. I hope that they're wrong about that, Representative. But I will not put my citizens at risk of being criminalized without standing up for their rights. I would hope that you would stand up for your people's rights as well.
Representative Powell, you need to follow up. Ma'am?
I'll be standing up for lives before I stand up for rights every day to protect my community. And you keep referencing Texas. This is Tennessee. Thank you.
And thank you for that. Next on the list, I have Representative Grills, Chairman Grills, excuse me.
Thank you, Mr. Chairman. Be appropriate, I call for previous question.
Very good. Previous question been called. Any objection? Seeing none, all those in favor of sending House Bill 2802 to Criminal Justice Full Committee, say aye. Aye. Opposed, say no. Bill moves on.
Look, guys, one person asked.
The roll call, the request for roll call was made by one member. It takes three. That's the rule. It's been the rule. But you can be recorded as a no. So Bill moves on to Criminal Justice Full Committee. Thank you. That brings to item 12, House Bill 2508.
Point of order.
You
Point
got
of
a motion
order.
in a second. I'm coming to you. I'm
Point
coming to you. Representative Powell, we're on House Bill 2508.
But I
now.
have
Let
a
the record show.
legislative inquiry for the clerk.
Sure.
If a motion is made for a point of order and that is not challenged, then how is there not a roll call vote taken? My colleague made a motion for a roll call vote, and I understand, but no one challenged that. No one challenged that.
You want? All right. Leader Lambert, would you like to answer that question?
Mr. Chairman, you and I have been here 12 years, and the good gentleman from Davidson County has been here that same time. The entire time we've been here, it's worked the exact same way. 3 members of the committee can request, not one, or the member who has the bill, the sponsor of the bill, may begin his presentation and ask for that. And I believe that could even carry it up any time to the point where they vote. The sponsor of the legislation can ask for just 1 or 3 members of this committee. I think the chairman explained that earlier, but I figured I'd make another go at it.
Okay. If I could, if we go back and look at the take, I just want to be on record. I yelled roll call. My colleagues here in the front turned around and yelled roll call. So there were 3 people asking for a roll call, Mr. Chair.
Yeah, thank you. All right. Item 12, House Bill 2508 by Representative Harris. You recognized. Do I have a motion in a second? All right, you're probably recognized. All right. All right. Here's where we're at. You all have interrupted this committee this entire hour and a half. So, and I understand that, but I need you all to refrain from yelling, speaking out of turn, all that. We have a couple more bills on committee, and then we're gonna adjourn. Representative Harris, you're recognized.
Thank you, Chairman. And House Bill 2508 simply would allow an individual who has an employer that requires a commercial driver's license the ability for them to be able to get that child support through their payroll and them be able to have access to an active CDL while they are employed. And that is the gist of the bill.
Thank you for that. Members, any questions for Representative Harris? I have Representative Chairman Todd, excuse me, you recognized.
Thank you, sir. I did have a question. What makes this any different than the regular?
All right. We're gonna take a 5-minute recess, members. All right, back in session. Thank you everyone for your patience. Chairman Todd, you recognize?
Thank you, Mr. Chairman. I move that we roll this bill, House Bill 2508, to the heel.
All right, without objection, to the hill. That brings us to item 13, House Bill 2001. Representative Garrett, House Bill 2001, Representative Garrett, you're recognized.
Thank you, Mr. Chairman. Mr. Chairman, I have an amendment coded 17483 to move, and that rewrites the bill.
Very good. Got a motion, got a second. Any opposition to adopting that amendment? Seeing none. House Amendment 17483 is adopted. So, sir, you're recognized on House Bill 2001 as amended.
Thank you, Mr. Chairman. House Bill 2001 as amended, all it does in a healthcare liability action, it abrogates the collateral source rule. With that, I ask for your support and move to approve the legislation.
Very good. Almost have Chairman Todd.
Thank you, Mr. Chairman. I move previous question.
Very good. Any objection? Seeing none, all those in favor of sending House Bill 2001 as amended to calendar roll, say aye.
Aye.
Opposed, say no. Ayes have it. The bill moves out. And that brings us back to item 12, House Bill 2508. Thank you. Representative Harris.
Thank you, Mr. Chairman. House Bill 2508 is my CDL licensure bill to allow more individuals the ability to have their CDL license while they're in the process of paying their child support. And with that, I renew my motion.
Very good. Thank you. I have Representative Parkinson on the list.
Thank you, Mr. Chair. Question on the bill.
Very good. Question been called. Any objection? Seeing none, all those in favor of sending House Bill 2508 to calendar and rules, say aye. Aye. Opposed, say no. Ayes have it. Very good. Larry Lambert, you're recognized.
Mr. Chairman, I think that's the final item on today's calendar, and I did want to just recognize you as a good friend and representative and a wonderful chairman. And I think you've handled yourself extraordinarily well the last 2 years. In fact, the last 12 years that I've known you in this body. So thank you for your leadership in this committee. I anticipate today would be the last day that we would have business, unless there's something out there I don't know about. But Mr. Chairman, I just want to thank you publicly from all of us for your leadership for this committee. Thank you.
Thank you, members. I appreciate that. Thank you. I know things aren't always easy here in committee, and we're dealing with difficult issues, and I do appreciate every member on this committee. I appreciate Elizabeth and Heather, Robbie and Ron, and our clerks and everybody that makes things happen. So I just want to give you all just my gratitude for all you do to make things work. And Chairman Russell.
Thank you, Mr. Chairman. I also want to say thank you for everything you do as the sub-chairman, and it's a pleasure to working with you in this committee. Thank you.
Very good. All right, members, without any objection, and I also want to recognize Vice Chair Jernigan. I know he's not going to be with us next year. It's been a pleasure working with you for a good decade plus, and you've been a great Vice Chair and just a great person to work with. We're going to miss your input and your leadership as well, sir. So we just want to wish you the best with all your future endeavors.
Thank you. Thank you. And thank you, Chairman. I appreciate your leadership over the past 2 years and really trusting me as being your vice chair and including me. And I do appreciate it. Thank you.
And thank you for that, sir. Okay, members, without objection, we're going to adjourn subject to the call of the chair. Thank you.